in criminal trials. That word is not trial, and I'm going to tell you the difference between the two. Criminal trials, which means we are looking specifically at maybe the trials in the north, trials in the south, which are each region bear their own peculiarity, right? And then we're also trying to look outside the purview of the civil courts, criminal litigation in the civil courts, as well as criminal litigation where before the military tribunals, as well as other tribunals. That was what your research assignment was. For you to just go on this voyage of discovery, for instance, let's even start with the military. How do they handle their issues? How do they try offending personnel? The first thing we have to note that we have general court martial and we also have special court martial. So each of these bodies have their own jurisdiction to try offend several offenses you can see under the Armed Forces Act. You have offenses like insurrection, failure to suppress insurrection, absconding on duty, that's a rule. You also have malingering. You also have sodomy. You also have the offense of, there's so many of them, that you normally find in drunkenness. Then unruly behavior. You also have the civil crime. A military can also commit a kind of crime the civilians commit. You understand? So that is when he commits these offenses outside the barracks, outside the purview of the military. We will now say, and is involving a civilian, that's when we say he has committed a civil offense. We call it a civil offense in that regard because we want to distinguish between the military offenses from the civilian offenses. Now, you also note, like, in the constitution of the court martials, before a death sentence can be awarded against anybody, before a military personnel can be convicted, the body sitting, that's the general court martial, has to have at least 7 military personnel sitting to hear the case. 7. The same thing applies if the sentence is for life sentence. But for other minor offenses, you have the special court martial, where you don't bother with the number of persons who, will sit, so long as the offense is not capital offense. If the offense is capital offense and what is in niche and the tribunal that is available is special tribunal, then it must comply with the rules governing general court martial. So nothing too special in the distinction of between the names, right? And then one other thing you want to know is who are the subjects of these very courts. The subjects of these very courts are only members of the armed forces. So when we talk about the armed forces, we're talking about the Army, the Air Force, and the Navy. Mind you, Road Safety is not included, EFCC is not included, ICPC, all of them, they are not included. Why? Because they are not of the armed forces. Right. So if you see a scenario where a military is arranged with a civilian or somebody who is also an enforcement agency officer. So try to distinguish between the two and find out which law actually binds who among them. All right. And then initially, when a conviction is made by a court martial, so what I have told you about the constitution, we're talking about the procedure now. In appearing before the court, the offending military personnel is brought before the court. And most of the times, there is, in observation, somebody called the judge advocate. The judge advocate could be a military personnel with knowledge of law. So his idea is to do what? To guide them during the trial, so as to ensure that the constitutional right of the offending military personnel is also done what? Observed. So the military is not, they are not above the constitution. Right, so that's why you have the judge advocate. But in decision taking, you do not count the judge advocate as a member of the court martial. The judge advocate is not a member of the court martial. And one interesting thing about the court martial is during trial, and decision is passed, and the decision is 50-50. You know what I mean by 50-50? Let's say out of the 7 persons, 1 person dissented. He doesn't want to give any opinion. He absents himself, making it only 6 judges sitting on trial. Now, in the decision, let's say 3 judges are for conviction, 3 judges are for acquittal. What will be the legal effect? Once there is a situation like that, it means that the defendant, that military defendant, must be discharged and acquitted. Why? Because the decision is 50-50. So apart from the decision being 50-50, who can tell me what is the underlying principle why that defendant must be discharged and acquitted? Someone tell me.
Because in criminal trial, any doubt must be resolved.
So you're saying that once there is a split in decision, it means that there's doubt. Is right. So any split in decision means that there is doubt. And that doubt must be nil in favor of the defendant. Right. So most of the times, and you discover that they don't, you don't have lawyers appearing there. But if they have military lawyers, I believe they can have military lawyers come to defend them. You know why I'm saying I believe, I'm not too specific, is because we can only talk about it if we have any military regime, but we don't have military regime. So the only reference we can make is in the past, and when you make this reference in the past, you discover that most of the things that happened in the past were basically abhorrent. Are you following me? When somebody just subjected to trial, the military, offending military officer is just brought. And when he's brought before the panel, let me call it panel or tribunal, he was taken, he asked to plead. They will read the charge against him, state your own case, prosecution states, you have questions to ask. Most of the times, especially those who brought us, right, and those who are alleged to have, committed coup, they weren't given any fair hearing. So that's not the kind of standard we should be discussing. Are you following me? Right. So we can also only talk about what is military procedure if we are practicing it now. So the best we can do about that is to make reference to the past. And like I've said, the past has nothing too good for us to appeal from proceedings of court martial lies at the court of appeal, lies with the court of appeal. So that's the most important thing we have to take note of, that when there seemed to be a reformation of the military trial, it was enacted that appeals from court martial would lie with court of appeal. All right. So we have been able to talk about one of the trial procedures. And then there are other tribunals. There are other tribunals that can also try, parties. But good thing about these other tribunals are they basically civilian tribunals. For instance, when we had the Fairbank Tribunal, even the Armed Robbery Tribunal, which is no longer in existence in most of the states of the Federation now. Why? Because the High Court have taken over trials of armed robbery and all that. Then, if for instance, we talk about the Fairbank Tribunal, the proceeding in the Fairbank Tribunal is very akin to the ordinary or normal civilian courts, which we are going to discuss. So that whatever we are going to discuss about the procedure applicable to civilian courts will apply to what? Fairbank Tribunal and other civilian tribunals. So that's why we are talking about trials. So we now zero into civilian courts, the civilian courts. When a suspect is arraigned, the first point of call for that arraignment is the magistrate. Because we're talking about the South now. Remember, we have in the past discussed about the North. In the North, apart from the first information procedure, the other procedure that I'm going to discuss also apply to them. Are you following me? So the basic difference there is the framing of charge, how the defendant is arraigned, how the suspect is arraigned and become the defendant and so on and so forth. So when a suspect is arraigned, his nomenclature changes to that of defendant. And if the offense is an offense within the jurisdiction of a magistrate court, a magistrate will try the matter. If the offense is outside or beyond the jurisdiction of the magistrate, then there will be that reference that we've already, the referral that we talked about last time. So let's look at where the magistrate has jurisdiction. Now, when a magistrate has a jurisdiction to try a matter, by way of procedure, the first issue that comes up is that of what? Election. Do you want your matter to be tried here or in the High Court? You're giving him options. You're giving options to the defendant. Either to be tried in the court below or at the High Court. And like I have said, so long as the magistrate court has jurisdiction, there's no need advising your client to elect to be tried at the High Court. So the proper election to be made is what? Trial at where? Magistrate court. Are you following me? Now, after the election is made, the next thing that follows is the question of plea. The question of plea. So we look at plea, and also we also want to look at some of the rules guiding taking of plea. Plea, like we learned last time, is the act of making the defendant to know the charge against him, the allegation of the offense against him, and for him to respond whether he is guilty or he is not guilty. And in plea, one of the foremost rules of plea is that a plea must be what? Must not be what? Ambiguous. Don't forget too easily. We've learned this thing. A plea must not be ambiguous. In other words, if the defendant is making a plea, his plea must be precise, unequivocal, and he must be understand to be intending the plea that he's making. He must be intentional about it. So if he pleads guilty, even if he's intentional about making a plea of guilty, the court, by the excellent provisions of AJA, must do what? Get him to know the consequences of his plea, in order that the court will be satisfied that the defendant understood the plea he is taking. If he says, Your Worship, I'm guilty, the court may ask him, did you mean you do this? You were the one who committed the offense. And he said, yes, sir, I committed the offense. The court can ask, did you have any reason for committing the offense? What is the reason in this circumstance? What is the reason? Defense. The court is trying to know whether you have a defense, because when you do something and you have a defense for doing it, it means your plea is what? That of not guilty. That's when the court puts up a plea of not guilty in favor of the defendant. Let's say peradventure the court gets satisfied that the defendant intended a plea of guilty, and then it has been recorded. The court will now tell him, by pleading guilty, I'm going to convict you, and after conviction, I will adjourn this case for sentencing. Are you following me? Now, do you think within this interim that the defendant can change his plea? Can the defendant change his plea? We are not reading. The answer is yes. The answer is there is two instances where a defendant can change his plea. If he has been convicted but not sentenced, an application for the leave of the court to change plea can be made based on evidence which prima facie shows that the defendant is exculpated from that crime, or the defendant has a reasonable defense. So a plea can be changed in that circumstance if the court grants leave. In other words, the court must be satisfied with the reason being given to the court. Again, the defendant may, when my lord says, I hereby convict you, but I'm going to adopt and say, hey, my lord, sorry sir, I made a mistake. Are you following me? There and then he can change it. He say, my lord, I didn't understand it like that. Why, even if my lord believes he's playing a prank, why would my lord listen to him or his worship? Why would the court listen to him? Even if the court believes he's playing pranks, why would the court listen to him? So that he is not committed for the offense he has not committed. Any other reason?
He is still presumed to be innocent.
Presumption of innocence on the contrary is proved. So, in other words, the prosecution is not even allowed to rely on the weakness of the case of the defense to say, I have proved my case beyond reasonable doubt. That yardstick must be applied. If by applying the yardstick, the court believes that the prosecution has proved this case beyond reasonable doubt, then so be it. But if that is not the issue and there is still a lingering doubt, then the court can rule otherwise. So for a defendant that had already pleaded guilty and is about being sentenced, and he comes to say, no, your worship, I have a reason. Maybe when I made that plea, I was under the influence of so thing. Maybe act of God. Maybe he feels he's being manipulated. He can even say he has a spiritual problem. Whatever he says, no matter how unreasonable it sounds, so long as he raises doubt, that doubt must be taken seriously and be resolved in favor of his application. Afterwards, if he changes his plea, the trial will still go on. Then the prosecution will now have the floor either to prove the case beyond reasonable doubt. One other thing we have to take on here is that a defect in plea will lead to an acquittal. A defect in plea will lead to an acquittal. If, for instance, and this person says, your worship, I believe that I made a mistake when I pleaded with worship. I've already written it. You're wasting my time. I can't cancel what I've written. What I'm telling you are the things you see in practice. We don't have enough record book. It doesn't matter. Between record book and constitutional right, which one should be supreme? Constitutional right. So if the matter is taken up on appeal, it will be treated as well a defect in plea. It will be treated as a defect in plea. So when there is a defect in plea, It will lead to the acquittal of the defendant. And then again, in taking plea, where a defendant is charged alongside other defendants, he can only take a plea on his own behalf. You can't take a plea for the co-defendant. Assuming there are 5, or even there are 30, instead of wasting time, no one person plead for us. If that situation arises and the court allows it, what will be the effect? The plea will be what? Defective. The plea will be defective. So a plea must be what? Personal. Plea must be personal in nature. No one defendant is allowed to take a plea on behalf of another defendant. Alright, so we've talked about when you can change plea, substitution of plea by leave of court. And then another thing, in the process, once plea is taken, as a court of summary jurisdiction, nothing stops the magistrate from saying, put in your witness the same day. Do you understand? It doesn't mean that the magistrate has violated anybody's fundamental right to fair hearing. It doesn't also mean that the presumption of innocence has been violated as a doctrine. No. Because as a court of summary jurisdiction, the court can go on that day in order to stop wasting time. Right. After checking of plea, the next thing is hearing. The next thing is hearing. And remember that if there is an objection to the constitution of the charge, the way the charge is, a preliminary objection can be taken. At what stage? At what stage will a preliminary objection be taken? Before the charge is read. But if you have other preliminary objection that is not related to the charge, at what stage will you take it? At what stage will you take it? At what stage? Well, you see, you can check it, but it depends. What you ask your mind, what you tell your mind is that it depends on the kind of objection that I'm raising. If the objection is on jurisdiction, it can be raised at any moment before judgment is given, even on appeal. You can still rely on the issue that this court that convicted my client having jurisdiction has been issued. Right. So that's the time where you can raise objection. But there are other objections that are also allowed in the course of trial. Let's say, for instance, the prosecution said, okay, Your Worship, I had Mr. ABC as my first witness. PW1, they call PW1, and he comes to testify. And under what reason may make the defense to object to a witness testifying for the prosecution? What reasons can you think of?
If the witness is a person of a sound mind, and to be the person is not a qualified witness.
Qualified how? Do you have qualification? If the witness is a person of unsound mind, is it not for your advantage? You are the defense counsel now. The prosecution has called a witness. And I'm asking you, under what circumstance can you raise objection to that witness giving evidence? If the witness is of unsound mind, it is your business. In the case of the prosecution, all you need to do is try to show is demolish their case, raise doubt. If the witness has interest in the case, in criminal matter, how can you show interest in criminal matter?
If the witness is like a paid witness, like he has appeared for other cases, or he's not.
You can't raise objection. You can't raise objection. If a witness is a suborn witness, that's what we call them, suborn witness. If a witness is a suborn witness, what he simply do is that show proof that he's a suborn witness. Do you understand? You look at what he does for living. Was he there when this thing happened? Has he in the past testified for people? Is he known to be that kind of human being? Even if you won't fully prove it, but at the moment you can cast it doubt. This man, you were not there. you were paid to come and say this thing against me. And the court is listening, and the court is weighing his evidence, watching his demeanor. And in the end, the court may have doubt. This thing this man said may be true. Because the yardstick for which the court will judge him now will be what will be played in the mind of the court. Is this person a sworn witness or not? Do you understand? Is he a witness of truth? So you discover that the test to assess him may be higher than the test that will be applied to by the court to attest other witnesses of the prosecution. Any other reason why you can raise objection for a witness coming to give evidence? Saturday, you raise your hand. What happened to your hand? Now, mind you that civil litigation, criminal litigation is mixed with what? Law of evidence. What if in a scenario, the prosecution has brought your spouse to testify? Who will tell me why would you raise objection?
Because the spouse is their considered as one, and you cannot compel the spouse.
Forget about one. Competence and compatibility. You can, the spouse is not a competent witness for the prosecution. That's the legal language. Not a competent witness for the prosecution. If she must testify, she must do what? Obtain permission from the other spouse. That may be the ground for you to raise objection. Any other ground? Don't tell me you've forgotten everything you read about evidence. Any other ground? This is basically lost witness though. Any other ground? What if the prosecution has brought your former counsel to testify against you? What will be your ground of objection? What will be your ground of objection? If your former lawyer is brought to testify against you, what will be your ground of objection? Okay. At what point in time will you raise your objection? Before he gives evidence or in the course of his giving evidence? At what point? Before. What if you were overruled? You know, that somebody was your former counsel doesn't mean he can't testify against you. But the question is he coming to testify against you using the information that he acquired or he came by while representing you? So some of the time the court will allow him to start giving evidence. So when you start going towards that area, you raise your objection. You can raise it before he is heard, or you can, if you are overruled, you can also raise it when he starts giving evidence that connects to that. But when you look at the charge against your client and you see his former counsel, you should be able to draw the nexus. If you're not ready and your worship sir want to ask for an adjournment because it is reasonable in the circumstance, we want a little time to help us prepare very well. We didn't know that this person would be coming to church because this is a court of summary jurisdiction. We were not notified of the witnesses that will be testifying for the prosecution. That would be a good ground to do what? To raise an objection or to ask for an adjournment. So when you go home, go back to your office, sit down with your client, you now start asking questions. What is the relationship of what he did for you in the past with what you are charged for presently, so that you will know whether to raise objection or not. Now, if the prosecution witness succeeds in giving evidence, the next thing that is done is that the defense counsel will do what? Will cross-examine him. After cross-examining him, the prosecution will have the ground to re-examine the witness if there is ambiguity. Which means re-examination is not as of right. You must show that there is ambiguity. Maybe that when this witness was under cross-examination, that he gave an answer that is capable of being interpreted to mean two or more things. Based on that, you say, your worship, that answer is ambiguous. You must point it out. Without revealing the answer, can the witness be allowed to expatiate, to explain what it means by this? Do you understand? whether by saying this he meant the other thing or he meant exactly what he has said. Re-examination is not allowed simply because a witness has contradicted himself. No, it's not a ground for re-examination. So if a witness has contradicted himself or contradicted evidence of other witnesses, it's not a ground for re-examination. Now let's take a scenario where all the hearing has gone on smoothly to the extent where the defense has to commence giving evidence. So at the close of the case of the prosecution, the defense will start calling its witnesses, if any, right? But if the defendant has no witness, the defendant will now go and do what? And testify. And when the defendant is giving evidence, you are leading him to look at the charges against him, to give evidence in line with the charges. Is he still denying it? Is there anything, such a thing ever happened? Then his evidence will be tailored towards telling us what happened between him and the allegation against him. He can also give evidence in debunking of the evidence of the witnesses who has testified against him. In other words, it's a second chance evidence. It's a second chance opportunity. For instance, if maybe he has raised an objection against a witness coming to give evidence, at that moment when he is testifying, he can attack the charge and attack the evidence of that very witness and tell the court, look at why this person has come here, because we have stuff for somewhere, and that is why he is now testifying against me. In the Lord, we recovered the knife with which he stabbed the deceased. Okay, let's say it's mentioned court matter now. We recovered the knife with which he threatened the nominal complainant, and the prosecution applies, your worship, we apply to tender this knife as exhibit in the trial. What would be your reaction? How will you do it? Now tell us, and let's learn. What will you do? Now, if at that point, there are two things, consider. There are two things that, two rules or three rules that guides admissibility. Take your mind back to evidence. What is operating in your mind at that moment? This knife, is it admissible? Is it not admissible? The fact that it may not be the knife goes to weight. Is it relevant? Is it connected to the case? This is criminal matter now. It's relevant because the charge said that so the lady, nominal complainant, was threatened by the defendant by waving either a machete or so. So which shows that machete is what? It's relevant. So for you to say there's nothing like that, your worship, no, it doesn't stop admissibility. Admissibility is different from weight to be ascribed to the admitted document or exhibit. The fact that a document, exhibit has been admitted against your client doesn't mean you have lost the case. The only thing you will now do is, during cross-examination, that's when you will debunk. What questions will you ask to debunk? Touching. What questions will you ask if the knife has not been admitted? What questions will you ask to debunk that it was not used? Your client didn't use knife to threaten anybody. What questions will you ask the prosecution witness to debunk the fact that your client never used that machete to threaten the nominal complainant? What questions will you ask? You said you will simply debunk it. So you only debunk by cross-examination now. So I simply debunk it.
The next thing I'll try to do, like you just said, is the admissibility of the evidence. If it's not,
been admitted now, it has been admitted. Let's not waste so much time. I have another lecture. It has been admitted. What question can you ask to show your client never use this knife to threaten anybody? Sit down.
Okay,
Someone
so
wants
we
to.
check if there's a witness.
No, I said what questions will you ask?
Probation.
What questions?
Questions of like related to the occasion of the crime.
Ask the questions.
Where was this knife kept? Something like the
If
location.
you are giving evidence that your client used this knife to threaten the nominal complainant, and then he was arrested and the knife confiscated, looks airtight, right? What questions can you ask to debunk it? I've already told you very well.
Was there any
Why would there be an eyewitness? It's not a big case that requires collaboration, no. Why would there be an eyewitness? You are trying to cast a doubt that this knife, my client has never owned a knife in his life. You understand? He has never owned a knife. So who else saw him with the knife? What other question?
also asked if the knife was found on this person when he was arrested?
They have already told you that they found the knife on, they retained the knife on him. You know, one thing I want you to know, in a case scenario, you may see a case printed so tight that it looks difficult. But in the course of cross examination, you see things will start, coming out. Do you understand? Right. Most of the times, there may be lies told against your client. And your client has come to you, my lawyer, save me. So it's your duty to save your client under that situation. So your mind, this document, this knife, have already been admitted as exhibit. How do I show that my client didn't use this knife? How do I even show that my client doesn't own a machete? How will I show that my client might not even have been there? How would I also show that? What about the place where the incident took place? Assuming the incident took place in the market, does someone go to market with a knife? Assuming it took place in the school, does somebody go to school with a knife or machete? Those are issues you have to sit down and so you don't see that you're doing theory. Time for you to start using your brain. It's almost here. All right. So at the closure of the case of the defense, his worship, the magistrate, ascribed time frame for filing and adoption of written address. And after that written address, the court will give its own judgment. So